Okay, so I'm going to start off here by giving a little bit of background. So Sam and I are currently doing a study that looks at community treatment orders. Community treatment orders are a type of mandated treatment defined in the Ontario Mental Health Act that allow a patient who has severe and persistent mental illness and meets certain criteria to be treated involuntarily while continuing to live in the community. So specifically, we're looking at the CTO process as it exists in Ontario and whether there's any room for improvements within this process. This is a process made up of many different elements, but specifically we're looking across at all of those different elements, but specifically what we're going to talk about today is the element of the Consenting Capacity Board hearings as they're related to the CTO. The Consenting Capacity Board being a quasi-judicial administrative tribunal which operates at arm's length from the Ministry of Health. So just to give you a little bit of an understanding of where this study came from. I have a background in working in a community mental health team, as Craig mentioned, here in the Ottawa area, where we were treating people in the community who had severe and persistent mental illness, mainly schizophrenia. And working as part of that team, I often worked with clients who had CTOs. So I had an opportunity as a nurse to witness that on one hand, CTOs could have a very positive impact on people's lives, but then on the other hand, they could also have these unintended negative consequences. And often the unintended negative consequences had something to do with the process that we were using to enact the CTOs and some steps in that process. So this led to a research study that I did as part of my PhD here at the University of Ottawa with the School of Nursing, an ethnography where I interviewed healthcare providers, clients, family members to ask about their experience of CTOs and the CTO process. And one of the things that came out of this was that people often, although they all agreed that there should be legal oversight and we should be protective of clients' rights, that they often complained about the sort of bureaucratic and technical legal elements of the process, and sometimes went so far as to specifically be blaming lawyers. So there was this thing that the process is good, but those lawyers, they don't really get it. And so there was this feeling like, oh, they're just focused on technicalities. That came up a lot. So here I have this client who really needs some sort of treatment, and then I'm being beat up here in this tribunal because I've got the date wrong on a form, or I didn't cross some T or dot some I. And then some psychiatrists also went so far to say that the way that the client got treated in the hearing, often by their lawyer, who allowed, in the words of the participants, allowed the client to dig a hole for themselves, that they saw this as a sort of reverse abuse of the client that was happening in the hearing space by the very people who were trying to protect them. So this was an interesting finding that then I had the opportunity to chat about with Sam, and was able to see some research that he was doing concurrently, where he was looking at CTOs, but from the perspective, doing a study that was using focus groups to look at the perspectives of lawyers. Oh, sorry. No, that's good. Oh, so I'll get there. Where he was using, I'll just give a little bit more of this background, and then I'll change some slides. So he was looking at the CTO, but from the perspective of legal members who are participating in the CTO. And a theme that came out in that research was that these legal professionals were often saying, you know, what we want to do is protect the client, but there's some problems with this medical legal process that we're using to protect the client, and that is that the doctors just aren't even putting in any effort. They don't seem to care. They have this paternalistic attitude, and they're not even taking sort of the protection of client rights seriously. So we thought this was very striking that we had this situation where we had two groups of professionals that both were interested in taking care of clients, both saw themselves as being protective of the client in some way, of wanting to improve the client situation, but and both saw the medical legal processes that were involved in the CTO as somehow problematic, but one was saying the problem is the lawyers, and the other was saying the problem is the doctors. So this led to, so I just want to pause because I wanted to thank you, Craig, for doing an acknowledgement of the Indigenous lands that we're on. And I also just wanted to pay respect to the Algonquin people. We're currently on their traditional lands, and they are the traditional guardians of this land. So we acknowledge their longstanding relationship with this territory, which remains unceded. So, looking at our two sets of research from our two independent studies, we decided that what we wanted to do was explore this theme that came out in the comparison more completely. And so we decided to do a study where we basically did a secondary analysis of the data from both of the two studies. And that's the study that's published in this paper here, Professional Values and Mental Health Tribunals, how healthcare professionals and lawyers' views are shaped by values and how this might impede reform. So what we found doing this secondary analysis, where we examined how these two professional value sets, which had this clash with each other, might prevent reform, we found that there was this clash in the two value sets, but we also found that there were areas of productive overlap where we felt like we could have interprofessional discussions about improvements to the CTO. And that's what led to the current study that we're involved in right now. So this study stems from the thesis that in order to address consistent concerns about the CTO process, we need to find a way to make improvements to the process that are acceptable to all of the parties involved. So the client participants, the family participants, the healthcare participants, and the lawyer participants. And that's the only way to really move forward with reform. And we're looking at reform to the CTO process quite broadly. So we're interested in improvements to the CTO that are at the level of practice, individual practice, policy, or at the level of the law. So as I mentioned, our study looks at all the aspects of the CTO, but the area of central concern that we're going to focus on today is the CCB hearings, the Consent and Capacity Board hearings that are part of the CTO process. The CCB makes decisions about CTOs in Ontario. It's similar to mental health tribunals in many other jurisdictions that use CTOs, including Australia. Sam obviously brings an international perspective to our study, and we have found that the international comparisons are very useful, looking at what's unique about Ontario and how things are done in other jurisdictions as well. So in Ontario, the process is the doctor makes an order for a CTO, then it's reviewed by the CCB in a hearing. In the hearing, in most cases, you'll have an applicant or the client who wishes to challenge their CTO, the treating psychiatrist who's asserting that the CTO is valid and necessary, and then the members of the CCB. So the CCB, instead of having a board, has 3 members. It has a psychiatrist member, a community member, or a healthcare member who's often a psychiatrist, a community member, and a lawyer member. And they need to decide whether criteria are met. And if they aren't, then they revoke the CTO. The CCB, like mental health tribunals in many other jurisdictions, is supposed to offer proceedings that are less formal and less intimidating than a traditional court. And so this, along with the fact that it's headed by that panel instead of a singular judge, is seen as appropriate in the mental health setting because both they're more accessible and they have that broader expertise. But we're going to be examining today the ways in which they work and don't work. So in our study, this is where we are at right now. So stage 1 of our study was to do in-depth interviews. We've completed 62 interviews. You can see with clients, lawyers, psychiatrists, allied health professionals, CCB members, family members, and advocates. We've also had the opportunity to observe several CCB hearings, and we're just beginning stage 3 of our study, where we're having focus groups that are mixed focus groups. So with people from all of these groups, or however many of the groups we can get into a room at a time, with the specific intention of saying, so these are the findings in the first part of our study. How can we look at that as a group and find improvements to the CTO based on these that are acceptable to all parties? And so focus groups where we intend to be solution focused and have that back and forth between different professional views. So one of the grounding principles of our study is this concern about client experience. And so just to sort of start us off here, and then I'm going to pass things off to Sam. is that our study did repeat this finding that I found in my earlier research and that I found in my clinical experience, that clients do find the CCB hearings experience quite negative. So these are some quotes. Number one, they don't know you from anybody. I just have my lawyer fending for me and my rights. The thing is, it's not really equal because it's 3 to 1. I'm lost. They just listen to the professional, the doctor. Going in, there's always hope that there's a way for you to reverse it. But ultimately, by the time I get the results, by the time I see that, that they're renewing it to confirm these findings, it's disheartening, it's discouraging, it's disrespectful that I went in there and put my heart and soul on the line. And you just turned around and just decided that we're not going to see things your way. We're going to agree with the doctor. We feel it makes you, let's find a word for it on Google. You're asking me what it's like to be abused. That's essentially what you're asking, honestly. I mean, you could Google what it's like, what happens to a person when you abuse them. But you feel a deadening of emotions. It makes you dead inside. So with this very negative client experience in mind, we've gone about we've set about to try to understand what's going on in the CCB hearings. And now over to Sam, who's going to discuss this in more detail.
Thank you. Okay, so that's, as Fiona said, the view of the clients of the hearings is very, very, very negative, and there was a lot more quotes that we could have put there. This is what the other groups said in general. Of course, not everybody agrees entirely within these groups, but there were very strong patterns that came out. And the first one is that the lawyers tended to think that the decisions are unfairly weighted in favour of the medical views in the tribunal. They said that the CCB is sometimes inconsistent in its decision-making. The lawyers and advocates think that the clients aren't sufficiently heard at the hearings, not literally unheard. They do get a chance to speak, but that they're not properly listened to. On the other hand, and this confirms what Fiona has found in her experience and in her PhD, that in our study, the healthcare practitioners really criticised the CCB for being too focused on what they call as technicalities. They also point out that some psychiatrists, these are not the ones that we interviewed, but all psychiatrists who we asked about agreed that some other psychiatrists would avoid using CTOs because of the onerousness of the process, including within that the difficulty of defending their position at the CCB. Now, this first finding from the lawyers, mental health tribunals, as Fiona says, in lots of different jurisdictions. The CCB is just an example of many around the world. And they've been studied for a long time. They've been around for decades. And for decades, when people have assessed mental health tribunals, this criticism, this first one, how it doesn't escape the medical model. They're biased towards the doctors. This is something that gets repeated over and over again in basically every jurisdiction in which this is decided in a tribunal. And as I said, across decades. So I've got 4 papers there, but I could put many more. So it really wasn't surprising when this view was repeated in our study. But I think that we can dig into it where our results allow us to dig into it and explain it a bit more. Firstly, here's just some examples of what people said about the tribunal, what lawyers said about the tribunal. By the way, there was a very distinct spectrum of approach of lawyers that I found. We talked to people from all over Ontario. And for whatever reason, the lawyers that we talked to in Ottawa were, for example, a lot less combative, I would say, than the lawyers that we spoke to in, you know where I'm going to say, Toronto, right? The first one is, I think maybe a non-Toronto lawyer who was quite conciliatory generally, but this lawyer said that he thought that there was a bias in the board about confirming orders. This was a more combative lawyer And they said, we are up against a panel that comes in with a mindset that is goal-orientated, that wants to affirm and uphold community treatment orders, that believe in them as a mechanism to keep people well in the community that they need to support. It's almost like they think they're part of the treating team. That institutional bias is devastating in the hearing context. So it's a very, very strong opinion that, and other people said similar things. So this is important for us to understand because, as the quotes that Fiona showed show, this idea that the panels are biased in favour of the doctors forms part of what the clients say is what they don't like about the hearing. So understanding it is important. And we think we can understand this a bit better, we think, if you dig into what the CCB has to decide. So for a CTO to be confirmed, there's 3 types of criteria that need to be met. The first is the initial eligibility criteria. In Ontario, it's not like this in every jurisdiction. So Ontario is a bit distinct in this regard, that you're only eligible for a CTO if in the last 3-year period, either you've had 30 days of admission into a psychiatric facility on 2 separate occasions, 30 days altogether, or within the last 3 years, you've been under a CTO. But that's fairly black and white. You either meet those criteria or you don't. So that doesn't detain the tribunal. What the tribunal has to think about mainly is what I'm calling substantive matters and procedural matters. These different matters aren't described as substantive and procedural in the legislation, but I think it's a useful conceptual way of splitting them out. This is taken directly from the legislation, but just for your understanding, I've distilled the essential criteria here. So what I'm calling the substantive criteria are, does the person have a mental illness? 2 is, because of that mental illness, do they need to be on a CTO? And 3, presuming that they haven't themselves given consent to the CTO, does that person lack the capacity to make those decisions to be on the CTO? So those are the substantive criteria. The legislation also gives a bunch of other things that need to be fulfilled before a CTO can be valid. So there needs to be a community treatment plan, a CTP, that's developed and signed by the client or the substitute decision maker. The person needs to be able to comply with the CTP, the community treatment plan. This is a special part of the Ontario law that both the person and their substitute decision maker have to have been advised of their rights by the Rights Advice Office. And the person's eligibility, they're meeting the substantive criteria, has to have been assessed within the last 72 hours. These sorts of things have to be demonstrated sometimes by forms, by signatures on forms, that sort of thing. So when we dig into what the lawyers think about the hearing being biased in favour of the medical view, really what they, I think, are thinking about a lot of the time is this substantive criteria, that it's in these criteria that the board accepts uncritically the medical evidence that's presented. And this is what some clients, this is a quote from a lawyer to represent that they said, oh, we don't really have a defence on the merits because we can't turn to anything that patient has done that we found that differentiates between or contradicts what the doctor has said or the hospital. So the merits are defined by the hospital. So what they mean is that on those substantive grounds, it's the medical evidence which carries the day. And so because of that, what the lawyers do then is focus on these procedural matters. And this was not a study quote because it wasn't during one of the interviews, but we spoke to one of these lawyers in another context and they said to us openly, we don't want to talk about the substance of the matters because then my client doesn't win the case. So I go for these things. This is what I focus on. Another quote to illustrate what happens, and this is another very combative lawyer who said this. I was asking them, how do you think we could improve community treatment plans? And their answer was, well, from my client's perspective, the most important aspect of community treatment plans would be to have the doctor screw up as much as possible. What they mean is that problems with community treatment plans is what they can attack in the hearings and possibly get the CTOs revoked. Now, so what happens then as a result of this is that these hearings, sorry to go back and forth, the challenge within these hearings really does focus on the procedural matters. And clients do, quote, win on those cases. Like a lawyer could successfully argue this form wasn't filled in or it hasn't been evidence that you had the assessment within 72 hours. The issue is, and this is a big but to that, assuming that the substantive criteria are still met, if a client wins on procedural matter, there's nothing in the legislation that stops the doctor from simply reissuing the CTO. So going and doing the advice, getting the form on the signature on the form or whatever it is, then they can just reissue it. And that is what often happens. I said that clients don't normally win on substantive matters. It's not fully true. One way that a client can, quote, win on substantive matters is this third thing on capacity. So if a client can convince the board that they actually have capacity to make these decisions, then the CTO can be revoked. And it does happen. But how do you demonstrate to the board that you have capacity? Well, this is what the lawyers said, this is what the client said, and this is what we saw with our own eyes when we were observing the hearings. That to convince the board that you've got capacity, you have to convince the board that you agree that you are unwell and you agree that you will take your medicine voluntarily. So you can see that no matter what, the client is caught in this medical view. They can't really get out of it once they've been put on a CTO and they go to the hearing. So this is what a client said. I'll just read the underlined bit. If you want to prove that you've got capacity, it basically means that you're going to cooperate with the doctor of your own free will. With regards to these, other than the capacity issue, with regards to these substantive issues, as I said, have I talked about the adversarial nature of the hearings? I think I missed that at the start, I'm sorry. So the CCB is set up to be a non-confrontational system, like more accessible than a court. And the hearing is made up of, the hearing panel has 3 people. But I would say the underlying structure of these hearings are still adversarial. Certainly, and when I say adversarial, I mean in distinction to inquisitorial. So that's that legal distinction. So you don't have, for example, an adjudicator who is seeking evidence themselves or running the case themselves. It largely depends on the parties and their lawyers as to how the case runs. The CCB panels can ask questions of the parties, but they don't run the case as can happen in inquisitorial systems. And as we know, an adversarial system in theory works the best where you've got competing evidence that the adjudicator gets to choose between. In these cases, is there really an adversarial challenge to these substantive matters? Well, I would say the answer is no, because the only person giving evidence on these substantive matters is the doctor, the treating psychiatrist. The client sometimes wants to talk about these things too. But if you've got a psychiatrist who's saying this person is unwell and they need treatment, and you've got a client who's saying, no, I'm not unwell, I don't need it, who's the panel going to listen to? It's not like you've got another psychiatrist who's representing the client there saying, no, they're not ill, they don't have bipolar disorder, or they don't need to be on a CTO or whatever. And it's not like, as happens in some jurisdictions, you've got a psychiatrist on the board who personally assesses the patient. that happens in the England and Wales system. You can have a psychiatrist on the panel, but they haven't seen the patient themselves. So what this means is that substantive evidence from the psychiatrist goes unchallenged. The panel does elicit this information. If the doctor, for whatever reason, is a bit poor with their evidence about one of these things, the panel members will then ask the doctor to provide evidence of those things. So the panel elicits that information, but it doesn't challenge it. So what we have is a system where the medical evidence is unchallenged on these central features. Clients can only win on technicalities, in quotes, in which case it can just be renewed, or if they agree with the treatment. In any case, they can't get outside of the medical model. And this is a big part, we think, of why clients' experience of the tribunal is so negative. As an aside, I think this also explains these annoyances that the healthcare practitioners have. The fact that you can't get a challenge on the substantive matters, and the lawyers are therefore kind of forced into challenging the procedural matters. This generates this sort of annoyance for the healthcare practitioners, which isn't ideal, but we can at least explain it. So because of those things, because of the ongoing dominance of the medical model that the client really get out of, we think that this proceeding is almost guaranteed to be upsetting and invalidating for the client, because these hearings are sold to the client as a means by which they can challenge their treatment, by which they can have their day in court, have their rights respected. The CCB members in all of the hearings that I saw were assiduous in starting out by saying, we are here to have the rights of this person tested in this court. We are here for this person. The doctor has the onus of proof of proving these things, and we want to hear from the client in relation to this matter. So it's sold as a way of the client being able to challenge the things that they want to challenge and to have their rights protected. But what happens is, and this is not intentional, is that instead the effect of the hearing is to really amplify the voice of the doctor, the medical view. Now, on its own, I think that's a negative thing, but it's more than that, I would say. And I want to share an experience that I had observed at these hearings. Excuse me. I found quite harrowing, actually. So in this hearing, a client, and I'll call her Mary, that wasn't her name, Mary was challenging her CTO. It was a phone hearing, and the psychiatrist who was defending the CTO hadn't been on Mary's case for very long, and it was a bit of a struggle for him because he didn't know all of the facts, all of the history very well, and often had to flick through his notes to find things. So he was struggling a bit to get all of the substantive issues down. He did eventually do it. At one point, he was talking about the second of the substantive criteria, that the person needs to be on a CTO. And when psychiatrists give evidence about that, what it, in almost every case, tends to be is they explain what are the negative things that happened to this client when they weren't on a CTO. And while he was giving that evidence, he related an incident in which, as he said, this client had run down a street naked. And at that point in the hearing, Mary interjected and said, I didn't do that. It wasn't a street. I didn't run down a street. And the chair of the hearing said, okay, thank you, Mary. The doctor is giving evidence now. You will get a chance to speak later. Thank you, but please don't interject again. Thank you. Okay, continue, doctor. The doctor kept giving the evidence. Now, by that stage, I'd been to enough of those hearings to know that by the time he had finished his evidence, it was all over. The CTO was definitely going to be confirmed. But the lawyer for Mary, I assume on Mary's request, when it was her turn to lead evidence, asked Mary to explain this incident. And she said something like, well, I didn't run down a street. And she said it was someplace, it wasn't such a public area. But she wanted to challenge that. The problem is that, like I said, it was already over. We had a psychiatrist who'd given that evidence. So for her, in this case, not only does she go into this hearing probably already knowing that she's going to lose, but she also has to sit there while this really embarrassing and exposing fact about her is said to a room of strangers, largely, and she can't say anything about it. If she interjects, and maybe she was correct, I suspect she probably was, because like I said, this psychiatrist didn't know the case very well, then she just gets shut down and the doctor gets to keep talking. I can't imagine how hard that must and horrible that is for Mary. And the fact of what I set out before, how the hearings unintentionally amplify the medical opinion, must make that kind of thing worse, because she probably knows from all of these previous hearings that people aren't really going to listen to her, that the doctor has the epistemic authority, that he will be believed kind of no matter what. So I think that's enough to show that there are problems here, that there are things that could be improved. It doesn't show what the improvements should be, but it shows enough, I think, to show that there's a problem. Okay. Now, I think I should at this point say, because you might think that my description of the challenge of the CCB hearings being mainly on these procedural matters, that sounds quite critical. And you might think, well, then what's the point of having a CCB hearings? If they're just looking at those procedural matters, doesn't that just become a box ticking exercise? And I want to give some reasons to say why I don't agree with that. I still think that there is important rights protections that come. One is that I think probably, as you would have thought, when I showed you those procedural issues, they include things like, has the person received rights advice? So I personally would never describe them as technicalities. They're there in the legislation for a reason. I think it's very possible and probable that the system is clunkier than it needs to be. Nevertheless, I don't think that we can dismiss all of these things as just technicalities, just nonsense. The other thing, and this comes from our study, is that decisions from the CCB affects practice of community treatment teams around Ontario. So we got that evidence from several places, the CCB members, the doctors and the lawyers, that when a CCB makes a decision about what you need to prove in order to show that the rights advice has been given, or what sort of consultation is required with the substitute decision maker, or one of those procedural matters, the CTO coordinators around Ontario pay attention to those decisions, and then that practice filters through to their practice. So I think in general, you describe that as a positive thing. So the system is working in that respect. Another point, that sometimes a CTO could be revoked due to a procedural flaw, but then it's not renewed due to a substantive matter. Now, we have no idea how much this happens, but we know it's happened at least once, because Fiona had an interview with a psychiatrist who was, at this point, complaining about the CCB being focused on technicalities. People get taken off them for silly reasons. And he was sharing an anecdote about a lawyer who was not one of those bad combative lawyers, according to the psychiatrist, because The lawyer won on a procedural matter, and so the CTO was revoked. But then the lawyer went to the doctor afterwards and said, you know, you can renew it. You can just fix that problem, go back and make it again, right? And this was said as an example of, so they're not all bad, these lawyers. But then he went on to say, but in that particular case, we had another look at it and we realized that, you know, they didn't meet the criteria for the CTO anymore. So we just didn't bother renewing it. And I read that transcript. I was going, aha, see, it does matter. So having this check in that one instance at least made the doctor have to think, well, do they actually meet the criteria anymore? And the answer for that doctor at that point was no. So given what might be a possible institutional bias towards confirming CTOs, having this check might be important in some cases. The other point, and this is something that I would put forward as a lawyer, is that having to jump through these hoops might direct psychiatrists' minds to how weighty the thing that they're doing is. Now, as Fiona said, the healthcare practitioners, the psychiatrists around the place, they know what a serious issue in relation to clients' rights CTOs are. It's not like they're not aware of it. But is it possible that sometimes they forget what a serious imposition it is? I would say the answer is definitely. And I think psychiatrists would sometimes themselves admit that. And so having to go through these hoops and go, we need to have this form done, then this, then this, then this, I think, at least from my perspective, is a benefit for having them have to think about what a weighty thing that it is that they're doing. And my argument that sometimes they forget, I think is backed up. Now, this isn't a typical psychiatrist. This person was definitely, like, the lawyers had a spectrum, the psychiatrists did as well. This is maybe a more combative psychiatrist, a more pro-CTO psychiatrist. Their comment was, I don't know any patients in my career who've suffered because they've been treated. I know a hell of a lot of patients and families who've suffered from a lack of treatment. So my bias, without wanting to sound cavalier, is I have no concerns about the rights of these patients being trampled on. Okay, so this is not a representative view, but it is a view of a psychiatrist who's treating people on CTOs in Ontario right now. And I think it shows that when you have as your main concern a healthcare perspective, which is very legitimate, but it is very possible when you have that perspective to sometimes forget what a serious imposition these CTOs are. And I think that I can back this up, and this is a sort of harsh contrast, but it's a really important point. I've sort of alluded to the fact that CTOs are a big imposition on people's rights. This kind of shows it. So how a CTO is enforced, if somebody stops following their treatment plan, so they start refusing their treatment, say, the enforcement mechanism is that the treatment team can call the police and say, this person is not complying with their CTO. Can you go and bring them into hospital, please? So the police pick this person up, take them into hospital. And this client said, you know, it's sort of like a coin flip. Sometimes you're going to get a nice cop, sometimes you're going to get a bad cop. By the way, this was supported by basically every other group that we talked to. Lawyers, doctors, advocates, everybody agreed that you have some really good police who have mental health training and do a great job, and you have some who don't have that training and don't do a good job for people with mental illness. So we can take this first part as very well supported. Second thing he says, and you know, it can be very scary, very, very intimidating to have someone show up your house and say, you're coming with us. And I bet I can't even imagine what that would be like. It's a serious thing. So given this is what we're talking about, given this is the context of a CTO, being, like I said, having the doctors being forced to jump through those hoops, I think has some value. Okay. All right. I want to talk about a related but different issue of how I think the underlying adversarial structure of the CCB kind of falls down. And it's in relation to so-called mandatory reviews. So like I said, clients can challenge their CTOs, and if they challenge it, they can go to the CCB and say, I don't want to be on it. But they don't have to challenge it. If they don't challenge it, every second CTO, and because the CTOs can only be 6 months, this means in effect every year, every second CTO has to be reviewed anyway. And these are the so-called mandatory reviews. Now, I spoke to 12 different CCB members. By far, the most common thing that they said to me about CCB hearings was, well, they generally said, things are going very well. We've got a well-running organisation, but those mandatory reviews, gee, they waste our resources. They said, you know, what various things like, not that we shouldn't have them, but do we really need to take so much time over them? Do we really need 3 people on the panel to do decide things? I mean, they're not being challenged. And I think that's a problem, right? Because from what I've showed before, we know that there would be clients who would just avoid going to the CCB because it is traumatic. So the fact that somebody's not challenging it doesn't mean at all that they don't want to challenge it or they don't want it to be challenged. So you certainly can't assume that from their lack of challenge. And the thing is, like I said, we're dealing with really important rights here. And we're dealing with really important rights. But the fact that so many CCB members thought that if it wasn't challenged, the proceedings were kind of pointless, show how this, I think, where the underlying adversarial structure kind of falls down, where you've got this basic view that judicial proceedings only make sense if you've got a challenge. So I think this is an area where the CCB, I know that these people aren't purposefully ignoring clients' rights. So I think this is a structural issue that's going on here. And we had a really interesting finding from the study that although most CCB members thought, oh, this is a bit of a waste of time, 2 different psychiatrists actually told us, you know what, those mandatory hearings, we should be questioned more on them. So the psychiatrists were actually thinking, this is more of an issue than what the CCB was. So this is, I think, a good quote from a psychiatrist. This psychiatrist here was, again, a person who's very strongly in favour of the use of CTOs. But he said, nobody's looking over my shoulder. And I'm a very reasonable physician, but, you know, would I trust every colleague to be doing everything? And even with me, I'm giving these medications, someone's got these side effects from them, maybe it needs more observance. And this would be of high importance, he thinks, for a small number of people. And he compares it to the Ontario Review Board, where, according to him, they're just checking the box and just saying, okay, you're telling us that, good. Thank you, doctor. Keep going, doctor. This other psychiatrist told us, yeah, at mandatory hearings, they should be asking me more. So I think this is a really important fact about the CCB. We presented this to the CCB hierarchy the other week, and they were interested to find it. Okay, and then the third thing that I want to talk about, the third possible area for improvement of the CCB is this point about the treatment. Now, as we've said, the main point of the CCB hearings is to decide should the CTO be continued or not. And so it's looking at the substantive criteria and there's procedural matters. And they are either met, and so it's confirmed, or they're not, and so it's revoked. But one of the biggest points about the CTO is what actual treatment is given under it, right? So you've got a CTO in place that gives the psychiatrist the authority to require the person on the CTO to take this medication. And antipsychotic medication can have really, really serious side effects. It can have effects on people's sense of identity. It can affect weight in serious ways, their sexual function, all sorts of things. Treatment has a big impact on the clients. And as was found in lots of other studies, the clients, when they get to a tribunal, sometimes that's what they want to talk about, because that's the big deal. They want to talk about how this medication that they're on really gives them these horrible side effects. But the CCB members and the CCB structure basically isn't set up to look at those treatment decisions. And a few of them said things along those lines. So one CCB member said, I don't fuss too much about the treatment because that's not our business what the treatment is. And I like this one. You got to imagine this being said in a really sardonic voice. Whether or not it's the appropriate amount of antipsychotic or not, who's to say? That being said, they talk about it in the hearings and sometimes in a little too much detail, in the sense that it's like, oh yeah, well, he's been given 150 milligrams of blah, 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 this time, this frequently. I'm like, that's great. Not sure what that's supposed to mean for me, but cool. So they don't want to talk about it. And it's fair enough, because their job really is to confirm or not the CTO. So the treatment that's being given under it is kind of beside the point. But the problem is, like I said, that's what the clients want to talk about a lot of the time. Now, treatment decisions are a big deal. And this is a example of a client who says something like that. At the CCB hearings, I'm not allowed to say anything about the bad effects of the medications or how they work. So they've tried to say something about it. The CCB says, no, we're not here to talk about that. But that, by the way, is what happens in Australia as well. So this is not an unusual thing. But one thing that is, and this is that repeated quote from the psychiatrist, but I've just underlined this point here, that when the psychiatrist was thinking about the review and the importance of being asked more questions, he's thinking about the effects of the treatment. He says, there's some serious side effects here. This is the kind of thing that needs a bit more analysis. Now, there is general comparability of the law in Ontario to other international jurisdictions. But on this point, Ontario is a little bit unusual. So in other jurisdictions around the world, there are different provisions for having a second psychiatrist come in and review the actual treatment that's being given. So in almost every Australian state, you can't have a CTO unless two psychiatrists have been involved in the actual process to put them on it. So you've always got two psychiatrists involved. In New Zealand a CTO has to be reviewed by another psychiatrist when it is issued. In England and Wales, it has to be reviewed after 6 months. If it's continued, they have an actual service, a second opinion appointed doctor service, where they have to go in and individually assess the patient and talk to members of the treating team. Like I mentioned, in some jurisdictions, you have a psychiatrist who's actually on the panel. I'm not saying that that's a great idea, but it is a way that you have another psychiatrist reviewing the actual treatment decisions. And in some jurisdictions, so half of the Australian states, clients or patients have a right to independently access a second opinion. So in Victoria, there's actually a dedicated second opinion service. And if the patient says, I want a second opinion, the treating team is obliged to help them get one. So every other jurisdiction I know of in different countries has at least one of these things. Ontario has none of them. So it is possible that in Ontario to have the CTO being made and the treatment being given by a psychiatrist that's never ever reviewed by another psychiatrist. In practice, it often is, because as Fiona told me, often you have the psychiatrist in a hospital and the community psychiatrist. So often it is, but it's not required to be. So that's something that might be thought about. And there's some really important reasons why having a review of treatment is a possible important thing. One thing is that, I don't know if you're be surprised to hear this, but lots of psychiatrists we talk to would like it. I proposed this to the psychiatrist. What would you think about if they were obliged to have an independent second opinion assess your patients to check your decision making? And she said, yes, I would love it. That makes a lot of sense. I would love to have a second opinion on every one of my patients that I've made incapable. And looking at my treatment plan, I would love that because I would be so grateful to feel reassured and validated about the plans that I'm making in my assessment. You know, a lot of the time you're running stuff by families. This is a substitute decision maker. And it's not uncommon for me to hear the SDM, substitute decision maker, say, whatever you want, you're the doctor, whatever you want. So this is a not uncommon perspective that the psychiatrists themselves actually want to have this review. And there's good reason to do it. I mentioned the second opinion appointed doctor scheme. This is in England and Wales. So they have to review a compulsory patient after 6 months. And this is the most recent data that's available from a couple of years ago. Most of the time, when they do the review, they actually agree with the diagnosis and the treatment regimes. Okay, so 3/4 of the time, there's actually no change. But there are a lot of times, all the other times, where change is suggested and the doctor has to respond to those changes. 18% of the time, it's only a slight change, okay? And only 4%, it's a significant change. 2%, the second opinion person says, this person doesn't meet the criteria for a compulsory treatment, so they shouldn't be on an order. Okay, so 2% is not a large number, but that's a lot of people. That was 200 people in that year. And 200 people who actually, according to another psychiatrist, didn't even meet the criteria. And so they had their CTO revoked. So having a second opinion is valuable. It's valued by the psychiatrists and it can help improve medical outcomes. The other big reason why a second opinion is valuable is that there's research to show that having more than one medical opinion available improves patient autonomy. This isn't just in mental health, just in all contexts. You can imagine if you're a patient who's making decisions about your care, if you've got two different doctors, even if they completely agree with each other, it makes it easier for you to participate in that treatment decision than just having one doctor saying, this is what I think that you need. So improved, and another point to that, basically all of the participants that we spoke to agreed that if it was possible, that improved patient involvement in their medical decision-making would be a benefit. So having a second opinion would be a small but possibly significant way that that could be facilitated. A few clients actually suggested this. And this quote doesn't show that, but it shows a client saying that there are times where they can have some debate with the doctor and say, could I get a lower dose of this or whatever? And there can be some negotiation. And they described this in very positive terms, but this was the exception, that most of the time they said, we don't have any input into medical decision-making. And a hope would be that if they had more medical opinions available, that would be more facilitated. One of the advocates we spoke to made this really important point, and you can think about this in relation to your own treatment. Anyone who's been in therapy and is engaged in that process of actively negotiating and talking with your healthcare providers knows how powerful that can be, and how empowering that can be, and how it can help you figure things out and sort things out and be reflective. And I don't think our clients have that luxury of being able to do that. And she was saying that clients need to be we need to facilitate the client's participation in their decision making. And so having a second opinion is one possible way for that to be. Okay, so we've talked about a lot of issues here, and really what we've done is hopefully make a convincing case that there are some problems. We haven't really put any firmly established solutions other than maybe having a second opinion. We are right now conducting focus groups, and with mixed focus groups, including in some cases with clients involved as well, where we point out these are the problems that people have found and the people they think, what are some solutions that might get other people on board? So this isn't our final set of possible solutions, but these are the types of things that we're discussing. So maybe the hearing could be redesigned, the CCB hearings could be redesigned with consultation with clients to try to take steps to reduce that very negative impact that they are currently having. As I said, allow clients access to second medical opinions in one way or the other. And thirdly, allow the CCB to review and question the treatment plan. So, like I said, at this point in time, the CCB says it's not our job to review the treatment, and that's correct. Under the legislation, that isn't their job. The problem is that's like, at this point, the only place where any review at all happens. One of our lawyers suggested that there be a mediated meeting maybe with a lawyer or some other advocate where they sit down, client, advocate, maybe substitute decision maker and doctor, and they have a negotiated mediated meeting where the client is able to say, these are the side effects I'm feeling, this is what I think about the treatment. And they get to have some sort of negotiation where there is a treatment that would be agreed upon by all of the parties. Most people that we talk to would agree that something like that would be good. This lawyer had asked the CCB if they were able to do that, because under the legislation, the CCB is able to order mediation, but he got the response from the CCB to say, no, we don't do that at this point. So it is possible, it is plausible, and like I said, there is currently no other forum for the treatment to be reviewed. And so we talked to the CCB about this, and their response was, well, we can't do that within the current legislation, right? What are we supposed to do? And it's true, they are in a big respect restricted by the legislation. But there has been one of the things that has been found in international studies and mental health tribunals is that when those topics come up, like the actual treatment that's being given, and some sort of negotiation happens between the doctor and the patient and the lawyer, this sometimes happens without the tribunal setting out to have that. And when it does, all parties actually feel really good about it. So there is some room there for that to happen. It might be able to be possible within the current legislation using the mediated power, or maybe it could just happen within the hearings themselves. But that's something that we're talking about. I think I've reached the end of my time, but I have to acknowledge, sorry, there's an elephant in the room. I don't know, you know what the elephant that I'm going to say. The elephant in the room in relation to mental health treatment in Ontario is that there are, as you would all know, serious problems that the mental health population is facing in relation to medical services, to housing, to addiction. And it's a perspective that some people would have, is to say, why are you worried about, rights of the clients before the CCB when they're dying on the streets? They don't have sufficient housing. We've run a focus group, and one of the people in the focus group said, why are you worrying about a second opinion when these clients can't get a first opinion? They can't get a CTO when they need one. And that is a legitimate response. But we think that nevertheless, these issues are still really, really important. Yes, the more acute issue is right now on the streets, but this is an ongoing thing, and it's not a reason to stop worrying about it. It's obviously a very important context of our study that we're looking at in Ontario, but we still think that it's worth pursuing. Thank you.
Thank you, Sam and Fiona. We have about 10 minutes for questions. So.
Very good, very interesting. Because I've been in Ottawa specifically as a visitor, without a car, I walk a lot. And so what I see every day are people who are on the streets living with some form of mental health challenge. But I'm also seeing people interacting with them that appear to be someone trying to help them. They're often in a team, and I'm wondering who they are. Sometimes they're wearing little gray and yellow vests, sometimes they're not. And I'm just kind of curious as to who they might be.
You know what, I can try to answer, and then I might defer to Julie here, who worked for a while with City Health. So there's a number of different people who it could be. Like when I worked on an assertive community treatment team, that's like the max amount of treatment that you can receive and not be an inpatient. And some patients with the max amount of treatment being offered to them, and often concurrently being on a CTO, were still homeless. So it could be people who are receiving intensive treatment, but are still homeless.
Some form of.
Yeah, it could be something that they're not on like a consistent roster, but there's something in Ottawa called intercity health, where there's basically healthcare provided right through the shelters. So it could be team members from there. It could be, you know, outreach workers from like the community. Some of the community health centers do like outreach vans where they go and they find clients. It's like a consistent client, but they might be living here one day and here then another day, and they're finding them. So do you have anybody else who you think it could be?
So with inner city health and some of like the peer outreach workers, right? So the peer, like it's people with lived experience who are also hired by some of these health groups to go out, because often they would have far more success in engaging those clients than a random nurse would initially, and they would help facilitate those.
Is because when you're trying to identify an alternative to a formal order, as you said, sometimes you can negotiate something if you have the right combination of people doing that. I'm wondering how often it is possible that you're seeing people in their natural environment rather than in a hearing room. And I'm asking that because I've seen differences in outcomes in the States where the judges will sometimes go to person's place and will make a different kind of response than they would probably do if it was a hearing. And they can see that the person is safe in their environment, for example.
Oh, so you think the judge might be more likely to see that the client is managing when they see them in their home environment? Well, that's very interesting. Yes. So an interesting thing just to throw in there is that right now, since COVID, all CCB hearings, none of them are in person. They're all by phone or video. And most of the time, because of access for clients to technology, it's by phone. So they are in their concurrent environments. Actually, we have had some data in the studies where people say the presentation of the clients actually was a confirmation of, even though it's not necessarily meant to be data that's used by the CCB, the presentation in an in-person hearing would act as confirmation of the need for the CTO that is now being lost during a phone hearing. Yeah, but I think like you are drawing attention to a really important issue, which is that people are living really complex lives with very layered issues, and context matters. Yeah.
Go ahead.
I was thinking, this is not a question rather than a comment. I was thinking, could be an idea for lawyers, those who are appearing, not all the lawyers, but the lawyers, those who appear in these kind of hearings. The importance of those lawyers to have a very rudimentary, a very basic understanding about how the medication works, the pharmacokinetic. It's not rocket science. It is how dopamine and serotonin and norepinephrine work and how they take the reuptake on the synapse. Those are very basic things anybody can understand. Because this is very important for those lawyers to have those training and to make it mandatory or make it regulatory to have those training and appear in those hearings. It could be done to the Provincial Association of Law who regulate the lawyers like Law Society of Ontario, because this is very, very crucially important. Because in medical illness, if people are not properly treated, it's almost like dead. There is no life in them, although they're just walking, they lost their mind. And the consciousness in the society is that when they are taking this psychosomatic medication, as if they're taking like a poison, they are going to so many side effects and so many harms are done. As one of the slides said very well, people don't understand so much of people are suffering because not being treated, or maybe that they are treated, but they don't want to get the treatment because of this misconception, mis ideas they are having about this medication, their side effects, basically. People doesn't know what their side effects are. And the other reason I'm telling is that any lawyer knows that it's unbelievable the capacity of lawyers, the clients, so much they are listening to the lawyer. And sometimes the clients may not listen to that extent to accountant, or maybe not to the doctor. But for lawyers, that is unbelievable. Even I could not believe it. The clients are listening to the lawyers. That's unbelievable. And I have done so many that kind of conversations and changes into family law. I think not in this area of law, but in the same thing, lawyers can bring a lot of changes by simple conversation because the client trusts them. That's why they are coming, because there are thousands and thousands of lawyers. They are not going to anyone. They are picking up one lawyer. That is because there is a big trust there. So lawyers can make a great impact on this.
It's a huge topic that you've discussed here. We could literally then talk for another 2 hours on it.
Yeah.
So a couple of things to say. One is that in that dichotomy or that spectrum of legal approaches that I found, that there is I can very much see a benefit to having lawyers who are conscious of the health context and do have this in mind. And several lawyers that I spoke to were like that and defended that approach. But from my perspective, I think it's very easy to see how simply that approach could then translate into I would say, an insufficient defense of their clients' rights. If you have the doctor the lawyer who becomes too much attached to the medical model, I would say that that's a problem, that the role of the system, the way that the system works is if there can be a genuine challenge. The other thing I would push back, I think, a little on the idea of having lawyers being required to understand how medications work. I'm sure that can't hurt. That's great. What I think would be more valuable is we heard that a lot of lawyers, for whatever reason, don't really talk to their clients before the hearings. So what I would say is more important than that, respectfully, would be that the lawyer talks to the client and knows where the client's at, what their particular experiences are. And I would say, I don't think that they need to know how the medication works exactly, but they need to know how the client experiences the medication. So if the client is having these serious side effects and they tell the lawyer needs to be able to listen to that and to be able to use that in the hearing. That's what I would say.
One final question.
It's just on this point about the lawyer's role. So you mentioned the CCB is concerned about mediation and do they have statutory authority? Did you get any data from the lawyers or the psychiatrists about how they felt about having a mediation step in this process? Did they provide any views on that?
I get to both answer this one. It's, so from the focus group and the interviews that I took part in, I think they found the idea pretty foreign. Like, people have been doing this for a long time, and people are a bit, they're like, these are the steps, this is how we do it. And so there is a lot of skepticism about it. Would you agree with that?
Absolutely.
Yeah, yeah. So there's a little bit of work to do there. Yeah.
You don't have anybody who's really.
No,
A couple of lawyers.
Yeah.
It wasn't the majority. Sorry, it wasn't the majority. And the person who said that he didn't want to be a cavalier but didn't care about trampling on rights, I put that to him and he said, "No, my God, no way." So there would be some resistance.